Back in the olden days, when people couldn't just access an infinite variety of pornography online, X-rated videotapes were big business, and their sale was only lawful in the Northern Territory and the Australian Capital Territory. In 1992, Alphaone purchased 3 adult video shops in Canberra. In order to trade, the company needed a licence under the Business Franchise X Videos Act 1990. A licence application required the delegate to consider whether the applicant was fit and proper to hold a licence. Alphaone applied for a licence, but it had purchased these businesses as going concerns. They continued to trade while awaiting the licence. Alphaone was really open about that trading. They seemed to hold the view that the licence would be backdated, so they would not ultimately be committing any offences. The licence application did not go well. The department asked for more information, and the company responded combatively, refusing to provide some information. All the while, Alphaone continued to sell its videos without a licence. The department sent investigators to the stores to confirm this trade. The delegate decided that since the company had sold videos without a licence, it was not fit and proper. The licence application was rejected. The company argued that it had been denied procedural fairness because it had not been shown the evidence provided by the investigators and because the delegate had not invited comment on whether they were trading illegally or whether that made them not fit and proper. Alphaone was successful at first instance, but in the federal court on appeal, their honours said procedural fairness entitled a person to put information and submissions to the decision maker. That entitlement extends to the right to rebut or qualify by further information and comment by way of submission upon adverse material from other sources, which is put before the decision maker. It also extends to require the decision maker to identify any issue critical to the decision which is not apparent. The decision maker is required to advise of any adverse conclusion which has been arrived at, which would not obviously be open on the known material. Subject to these qualifications, however, a decision maker is not obliged to expose his or her mental processes or provisional views to comment before making the decision in question. The department prevailed, and this case establishes important parameters for the right to procedural fairness.